And thank you for your patience on the matter. I will call to order the Coastal Resources Management Council's Rights of Way Subcommittee to order. On our agenda this evening is the Spring Avenue Rights of Way. Prior to commencing, I'm going to turn it over to Executive Director Willis just for some updates.
Thank you. Thank you, Mr. Chair. First off, again, apologies for the meeting scheduling in January. Entirely on my shoulders. We did not advertise it correctly with the Secretary of State, so we could not hold the hearing. Again, my apologies for that. However, we have set up additional meetings, this one in April, and we have already started the process of setting up additional meetings that are more frequent in line and hoping to get some, probably not once a week, but pretty close to that. There's a lot of information to go through, and we want to make sure that we do it in a timely fashion for you all. So again, thank you for your patience on that. We will get through this.
Go do the housekeeping, please.
So we're probably going to schedule the hearing to go till about 9 o'clock. We'll take a break about halfway through around 7:30. We know we have a lot of material to get through, but I think that might be a good schedule for tonight. After that, again, we have the meeting scheduled for April, but we might have one scheduled before that. We'll let you all know if we do one before then as well, but we definitely have one scheduled for April. Restrooms are in the back, exits are in the back if we need to, and exits over here to my left, your right. I think that's it for now, Mr. Chair.
Okay. If we're ready to proceed, I'd ask the parties to pick up where we left off last time.
I guess Joe Priestley to resume the stand. I don't know where the witness should sit. Okay, very good.
I think we're going to have him right here, actually.
Direct.
Mr. Rubin, I think we're going to have him at the end here.
Okay, yep. And he'd be available for redirect. Just while he's taking the stand, just a small logistical thing. I discussed.
Excuse me.
Way over there. I discussed this with Mr. Farside earlier. We have a witness who has a lot of family health issues. Can really only come for one night. He has illness himself and he has to take care of his wife. So we're hoping that on April 13th, he could be the first witness and we could suspend whatever other witness was pending. So we didn't have to come twice. The lay witness, not an expert.
Yes, Mr. Willis.
Mr. Rubin, if we schedule a meeting before the April one, is it possible to get that witness at that time?
It would be, again, under the same circumstances that you'd only have to come that one night.
Thank you.
The subcommittee knows the far side from the Weekapaug Fire District.
Can't hear you.
Subcommittee, can you hear me now?
No.
Good evening, Joe Farside for the Weekapaug Fire District. I have no objection to the witness referenced by Mr. Rubin being scheduled to attend at the next hearing. And we can start with that witness due to his health situation.
Thank you. Where do we stand with Mr. Priestley?
I believe we're going to commence cross-examination
Okay.
now, as long as the subcommittee is ready.
Yeah, we're ready.
Okay, thank you.
Excuse me, can we get a witness microphone?
Remind me, like, always, yeah.
Wait a minute. That's just
Okay.
Is it on?
I'd like permission to just to hand the witness a binder that he can follow along.
Sure, while you're doing that, Attorney Hartman wants to swear him in.
So it's been some time, and I would just actually, Mr. Police, I'm going to swear you in for the testimony tonight. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Can you please state and spell your name for the record?
Joseph A. Priestley Jr., JOSEPH APRIESTLEY
Thank you.
Good evening, Mr. Chairman. William Conley for the town of Westerly. I just noted that some kind of binder was just presented to the witness. Could that also be presented to council so that we can see whatever the witness is looking at?
So the binder contains documents that are the exhibits filed in the course of direct testimony, Mr. Priestley, and were admitted into evidence on November 4th. It also contains certain documents that are going to be filed by the fire district in connection with the anticipated cross-examination testimony pursuant to the 7-day rule. So any documents that are new, that are district exhibits, there will be an opportunity for the proponents to object thereto before they're admitted as evidence in the matter.
Nevertheless, if something's going to be in front of the witness, I think that counsel ought to have the opportunity to see the same thing that the witness has. It doesn't seem fair that, right, some kind of binder should be presented to the witness and the other side not even see what it is.
So we can take the binder back from the witness, and we can hand up each individual piece of paper.
That'd be better.
Thank you. Evening, Mr. Priestley.
Good evening, sir.
You are being or have been paid for your work on behalf of Ms. Contrada, correct?
Yes, sir.
Including your work serving as an expert witness for her in this matter, correct?
Yes, sir.
Including your work informing the opinion that Spring Avenue Extension is public, correct?
Yes, sir.
And you've been paid a total of $20,000 for that work, haven't you?
Yes, sir.
And from what people or entities did you receive that $20,000 for your testimony?
I think it was from, I can't, you know.
The Save the Bay, one of those entities?
Thank you, yes.
And do you recall how much Save the Bay contributed to your expert invoice here?
I received two payments, one of 15,000 and one of 5. And I don't know, and I know the second one came from Safe Day. I don't know.
Okay, your testimony back on November 4th, you talked a lot about what is involved with running title on a piece of real estate, correct?
Yes, sir.
But you did not personally actually run title on Spring Avenue Extension, did you?
I did indeed.
You did.
Yes, sir.
And did you ever publish a title report?
I published a report in the conclusion. I didn't. Yes, I considered that a title report, but it wasn't, all of the deeds and everything else. But I ran all the deeds and everything else. I have done.
You agree the conveyances in Weekapaug occurring between 1884 and the present are all relevant to ascertaining the intent of the developers of property in Weekapaug, correct?
I would say on this one, you go from 1884 to about 1939.
Recall giving deposition testimony in this matter?
Yes, sir.
Do you remember being deposed on May 29, 2024?
I remember being deposed twice. I don't remember the dates.
So on page 31, line 3 of that deposition, you were asked, so in other words, the conveyances in Weekapaug occurring between 1884 and say 1984 are all relevant to ascertaining the intent of the developers, correct? Your answer to that was yes, sir. Do you recall that?
No, but if it's there, I may have said it. But I think my qualification this evening is more accurate.
Now, you believe that the developers of Weekapaug were sophisticated and knew what they were doing, correct?
Yes, sir.
This is despite that the original developers were foreclosed upon in the early 1900s, correct?
Yes, sir.
And this is despite that the developers frequently recorded deeds referencing plats that were not recorded, correct?
Yes, sir.
You agree that Spring Avenue Extension was never conveyed to the town by way of a deed, correct?
Yes, sir.
Now, in your opinion, there was never a dedication of any kind of Spring Avenue Extension to the public prior to 1921, correct?
with the recording of the Mackenzie plat. That's correct.
It is your view that the 1921 recording of a plat dated 1920 effectuated an incipient dedication of roads shown on that plat to the public, correct?
Yes, sir.
I'd like to show the witness Proponents Exhibit 1, which is the 1920 Mackenzie plat. Counsel, thank you.
Thank you, Joe.
If I may, for future reference, we've included the copy with the Proponents Exhibit at the top in red. Briefly. You recognize this Exhibit 1?
Yes, sir.
Shawmut and Meadow Avenues appear on this 1920 plat. You see that?
Yes, sir.
So according to your theory, they were incipiently dedicated at that point in time. Is that correct?
Yes, sir.
But you were aware that Shawmut and Meadow remain private to this day, even appearing on the town's official list of private roads, correct?
Objection. There is no official list of private roads for the town of Westerly, so the question, first of all, assumes facts, not evidence. And whatever list of private roads may be referred to by the fire district needs to be authenticated as, I said, called official list of private roads before it can be referenced in any questions or other evidence.
Thank you, Mr. Conley. Your objection's noted and the witness can answer.
Could you ask the question again, please?
Sure. You are aware that Shawmut and Meadow remain private roads to this day, even appearing on the town's list of private roads, correct?
Objection for the reasons previously stated.
You may answer.
Noted.
I've not seen any list of private roads, but I think they were incipiently dedicated and then accepted in 1939, so that they're not technically private roads. They may be privately maintained.
I'm going to now show counsel for the proponents a list of private roads, Westerly, Rhode Island, that was produced to us pursuant to an APA request in the town of Westerly.
So the town of Westerly objects to this proposed exhibit. First of all, has no indicia of authentication. Just because some document is produced pursuant to an Access to Public Records Act request doesn't require any authentication with it, doesn't require any indicia of reliability, doesn't tell you how it was created, what it means, nothing. So simply production through an APA request is utterly meaningless in this hearing. So first of all, on authentication. Secondly, on whatever grounds of relevancy, even if at some point in this hearing it can be authenticated, which as representative of the town, I seriously doubt, what is the relevancy of a list of private roads to a determination of whether or not Spring Avenue should be designated as a right-of-way by this body?
Thank you for the opportunity to respond. The document was produced to us by the town. It bears the date February 2022 on it. The document proves, if nothing else, that the roads on the plats relied upon as having become public by virtue of being stamped by the zoning board and the highway commission, actually those stamps did not effectuate an acceptance of the dedication, because those roads appear on this private road list produced by the town. Therefore, the document is probative. The fact that it's produced to us by the town makes it authentic, sufficient for purposes before this body.
Mr. Conley?
Yeah, so again, a document produced pursuant to an Access to Public Records Act request does not self-authenticate in any way. There are specific rules about self-authentication. APRA is not one of them, both by the rules of civil procedure and by statute. I'll cite to them, so remember them. This document does not meet the standard for self-authentication. So just something produced by an APRA that says list of private roads in Western Rhode Island doesn't mean it's exclusive, doesn't mean that it's official, doesn't mean anything. In addition to that, we now understand better that there's about 3 legal assumptions made by the fire district, as just presented by Mr. Farside, in order to get to some kind of relevancy. Now, at some point, while I understand that the strict rules of evidence don't apply, there needs to be something more than legal theory, unproven, speculation, unproven, legal theory, postulated, speculation, unproven, before something gets to be, and then claim that it's relevant. So there's a long road to go before this kind of a document should be submitted to this panel for any reason whatsoever.
So what I'm going to say is, I get to use some Latin tonight. It can be accepted de bene, which means that it can be accepted and it goes to the weight of the arguments here, go to the weight of the evidence. So the subcommittee can consider it, but they should assign the weight that it's worth based on the arguments that were presented here.
Thank you.
And that means the town reserves the right now to show later, if it comes into bene, the town will have the opportunity to show that this is not an official document. And when this panel hears that it is not an official document and it does not inform this panel officially that these are private roads, that all this testimony will be stricken from the record.
That argument can be made at a later time,
Thank you.
but it's going to be accepted for the purposes of tonight's hearing, and the subcommittee can reserve on making that determination.
And thank you. And so for the record, the town reserves the right to make that showing to this panel. And will at that time make the appropriate motion to strike all of the testimony that is based on this unofficial list of roads.
Understood. Thank you, Mr. Conley.
For the benefit of the subcommittee, copy of this document, which is labeled District's Exhibit 1, appears behind the tab A1, your binder. Okay, Mr. Priestley, can you please look at District's Exhibit 1? You see that the caption of the document is List of Private Roads, Westerly, Rhode Island.
Yes, sir.
Now, if you please look and see that the roads are listed alphabetically.
Yes, sir.
Can you please look at the bottom of the left-hand column? You see the words Meadow Avenue listed there?
Yes, sir.
And can you please look in the right-hand column? Tell me if you see the words Shawmut Avenue that appear there?
Yes, sir.
Please bear with me. Despite this, it's your view that Shawmut and Meadow were incipiently dedicated back in 1921 along the Spring Avenue extension, correct?
Yes, sir. Relying on the records of the land records, and this is not the type of document I would rely on as part of my examination. Even if it happened to be the records of the Department of Public Works.
Is it not possible that they remain private to this day because they were never accepted by the town?
Not my opinion that they were. I think they were accepted back in 1939. I told you why. I think also that the records show that at least Ninigret was accepted beforehand because at the time of the deed of Spring Avenue in the town in, I think, 1939, maybe 1940, I forget. But they were a requirement of the town to prevent that from becoming a one-way street. A dead-end street was that they continue it to the north subsequently and tie into the public road. If Ninigret hadn't already been accepted, it would have been a dead-end street in both directions, and they would have required the acceptance of Ninigret.
Once again, you recall being deposed in this matter?
Yes, sir.
You were asked on page 39, starting at line 21 of your May 29, 2024 deposition. Does it surprise you to see Meadow and Shoma on the private road list? There was an objection. You answered no, sir. You were asked why not. You then stated there was an incipient dedication of the roads. There may never have been an acceptance of them, or the town may never have chosen to repair them. Do you remember that?
So, yeah, I don't remember it, no, but I don't deny it.
Now, Shoma and Meadow also appear on the 1939 revision to the 1920 plat, correct?
I don't have it in front of me, but yes, they do.
I'm going to hand the witness what's been marked Proponents Exhibit 7. I'll show it to counsel first.
Thank you, Joe.
Have you had a chance to take a look at this exhibit?
Yes, sir.
Okay, and for the subcommittee, this is exhibit number 7 in the front part of your binder. Now, this document is stamped and signed by the zoning board and the highway commission, correct?
Yeah, it's not really clear on this copy, so if they have them, yeah.
I agree it's not clear, but we can agree that it's there. According to your theory, those stamps signal acceptance of all the streets shown on the plat, correct?
Yes, sir.
They don't just signal acceptance of just some of the streets on the plat, correct?
Correct.
Yet Spring Avenue Extension does not appear on the private road list, does it?
Which list are we referring to now?
District's Exhibit 1.
Oh, that unofficial list that doesn't have all of them on it?
Yes.
No, it doesn't, sir.
I'd ask Mr. Conley to withhold from testifying in response to the questions that were asked. Thank you. If, as you contend, Spring Avenue was incipiently dedicated to the town in 1921 with the recording of the 1920 plat, why was it later necessary in 1939 for the Weekapaug Beach Company to deed Spring Avenue north of Ninigret Avenue to the town?
An incipient dedication, there's 2 steps in it being accepted, and the hardest one to prove has always been the acceptance. With a deed of it to the town, there's no difficulty at all proving the acceptance because you've got a deed to the town. Now the town wants the fee rather than an easement.
So by your logic, the town already owned an easement over that roadway, correct?
An easement had been incipiently dedicated to them at the time of that deed. The 1939 map where it was accepted wasn't recorded till several months after that deed. So I can testify to the incipient dedication in 1921. I have no testimony between 1921 and 1939 about public acceptance. That wouldn't be within the title records.
So the Weekapaug Beach Company went through the effort of deeding Spring Avenue North to the town. Spring Avenue north of Nineveh to the town, and at the very same time dedicated all these other streets for public use through the indirect and uncertain approach of recording a plat. Do I have that correct?
And made less uncertain by going before the zoning board and the highway commissioner pursuant to the statute, which is one of the nice things about that statute. It takes the second step and solves the time by the recording on a stamp map, but that you don't have to look afterwards for evidence of public acceptance.
But why not just deed all of the roads, including Spring Avenue extension to the town, to avoid the ambiguity that we're faced with here today, 85 years later?
Objection, there is no ambiguity. Object to the form of the question. It's cross-examination, but you can't just create and facts not a record by using terminology that doesn't accurately reflect the evidence in the record.
Attorney Farside, could you rephrase?
Sure. You agree that we're at a hearing to determine the fate of who gets to own and use Spring Avenue extension, correct?
Yes, sir.
And it's been 85 or so years since the supposed acceptance of that Spring Avenue extension by the town, correct?
Correct.
And had the Spring Avenue extension needed the town, it's unlikely we'd be sitting here today asking who owns or could use it, correct?
Well, I think they may well have thought that since they stamped it by the zoning board and the highway commission, it would be unlikely we'd be sitting here 80 years later, but here we are.
When the deed to Spring Avenue north of Nineveh was made in 1939, there wouldn't have been much more trouble to include Spring Avenue extension in that deed, correct?
Objection, we have no idea what much more trouble means.
Yeah, Attorney Farside, I can have you rephrase that as well.
In order to include Spring Avenue extension in the 1939 deed of Spring Avenue north to Nineveh, north of Nineveh to the town, that same deed could have effectuated the transfer of Spring Avenue extension with the inclusion of some additional words in the deed itself, correct?
That would have changed the situation because with the acceptance of the map, the town doesn't have the obligation to maintain unless they go a step further. And in this case, if you deeded it, they own Spring Avenue extension now. They have an obligation to maintain that. They don't have an obligation at that point, with according to this map, to maintain the other road shown on the map, but they do have the public access. So yes, you could draw a deed. It's easy enough to draw a deed and include anything you want in it, but there's reasons why you wouldn't. And in this case, there's a significant difference between owning the fee and having the road dedicated to the public.
It's easy enough to draw the deed, correct?
Easy to draw deeds.
But that's not what happened, correct?
Correct.
Now let's talk about the 1923 statute for a minute, chapter 538 of the public laws, correct?
Yes, sir.
I'm going to hand council a copy of Proponents Exhibit 5 from the November 4th.
Hold on.
Thank you.
I handed the witness a copy of statute which appears in exhibit in tab number 5 in the front part of the subcommittee's binder. Mr. Priestley, does this appear to you to be the 1923 statute?
Yes, sir.
You referenced this earlier in your testimony tonight, correct?
Yes, sir.
Before this case, how many times have you applied the 1923 statute in your title work?
Never.
So this case is the very first time you've dealt with the 1923 statute?
It's also the very first time I've dealt with a plat that was stamped pursuant to it. Yes.
I'm going to strike that as non-responsive, move to strike that as non-responsive.
Oh, I think it's very responsive. I think it answers the question precisely and very clear and explains to this committee exactly what the purpose of this witness was for referencing that statute. So I ask that it remain in the record, perhaps even be highlighted as being important.
This is your first time with the statute, correct?
Yes, sir.
Thank you. When did you first become aware of, strike that, how did you first become aware of the 1923 statute?
Mr. Rubin gave me a copy of it.
Thank you. Despite the fact that this is the first time that you've used the statute, you still consider yourself qualified to opine on what the statute means and requires, correct?
Yes, sir.
Now let's talk a little bit about what the 1923 statute says. In sum, it says you can't dedicate a street or way for public use in Westerly without following the procedure in the statute, correct?
Yes, sir.
And it's your view that the statute goes to both dedication and acceptance. Do I have that correct?
Yes, sir.
Now, the 1939 plat you have before you, nowhere on it states that it was filed or recorded pursuant to the 1923 statute, correct?
The fact that it's stamped by the zoning board and the highway commission indicates that it was. There'd be no other procedure that I'm aware of for it to have been stamped by those two.
Have you reviewed section 2 of the statute?
Yes, sir.
Section 2 requires a road, quote, profile be filed with every application dedicating a road to the public, doesn't it?
Yes, sir.
And the road profile is required to not only show the location and width of the proposed street, but also grades and location and grades of all connecting streets and to be drawn to scale, correct?
Yes, sir.
And you are not aware of a road profile having ever been submitted for Spring Avenue extension, correct?
No, sir.
Thank you. And compliance with section 5 of the 1923 statute is a prerequisite to a street being dedicated as a public highway, correct? Take your time and read section 5 if you need to.
Yes, to the satisfaction of the Board of Highway Commissioners.
And what section 5 specifically says is, upon the filing or recording of any such plan pursuant to the provisions hereof, such street or way shown thereon shall not be open to travel or otherwise dedicated for public use. Do you see the word dedicated appearing there?
Yes, sir.
When you testified on November 4th about section 5, however, you omitted the word dedicated from your summary of that section, didn't you?
I may have.
And section 5 requires a road or way to be cleaned of stumps, rocks, roots, and other superfluous or objectionable material, correct?
To the satisfaction of the Board of Highway Commissioners at the time,
And all work and excavation and embankment to be brought accurately to a subgrade, correct?
as the Board of Highway Commissioners may require,
With corners of intersections rounded and granite bound set at all angles, curves, and corners, correct?
according to the direction and approval of the Board of Highway Commissioners. Yes, sir.
And sitting here today, you believe section 5 was complied with as regards Spring Avenue extension, correct?
Yes, because the map in 1939 was stamped and approved by the Board of Highway Commissioners.
In fact, that stamp is the only basis you have for believing that section 5 was complied with as to Spring Avenue extension, is that the Highway Commission stamped the 1939 plat, correct?
Yes, sir.
You have no other proof that section 5 was complied with as to Spring Avenue extension other than that stamp, correct?
That's correct.
And that view is true even though Spring Avenue extension has been impassable for decades, if not longer, correct?
Yes, sir.
Now, the 1923 statute nowhere expressly states that the stamp by the Highway Commission means section 5 was complied with, does it?
I just don't see why they would stamp it approved if it wasn't complied with.
You don't see why.
No, I
correct?
don't.
In fact, the 1923 statute section that provides for a stamp of the Highway Commission appears prior to section 5, doesn't it?
No, it doesn't.
Where does it appear?
There's a referral to the, who says town council here, which turns out to be the zoning board in section 3. And then the approval of the plan comes in section 5. All of those things being subject to the approval of the Board of Highway Commissioners.
So it's your interpretation that the words according to the direction and approval of said Board of Highway Commissioners appearing in section 5 modifies all of the words in section 5 preceding that statement, even the ones before the semicolons, correct?
Yes, sir.
Now going to show proponents counsel and the witness proponents exhibit 6, which is the deed of Spring Avenue north of Minnegrett to the town. For the subcommittee, this is behind tab 6 of your binder. Do you recognize this as the deed of Spring Avenue north of Minnegrett to the town of Westerly in 1939?
Yes, sir.
Do you recall that pursuant to this deed, the Weekapaug Beach Company agreed to clear, grade, and stake Spring Avenue north of Minnegrett?
Yeah, if you're referring to the paragraph just before the witness paragraph in the second page, I believe that applies to the part heading further north beyond that plat of Spring Avenue that the town required so that this stretch of Spring Avenue would not become a dead-end street.
I'm actually referring to the paragraph at the bottom of page 1 of the deed, which begins with the words, as a part of this deed and in consideration of the fact that the town hereby accepts the land herein before conveyed for use for highway purposes, and in order to provide for the future so that said Spring Avenue will not be a quote, dead-end street, end quote, so called. The grantor agrees to dedicate as a continuation of said Spring Avenue as above described for use for highway purposes, a strip of land 50 feet wide to be staked out at the expense of the grantor, again, the Weekapaug Beach Company, the location and grade of which shall be subject to the approval of the Highway Commission of the town of Westerly. Do you see those words?
Yeah, and it then describes what they're required to stake out, which runs basically north from Spring Avenue extension as it's shown on the 1939 plan, up to the Taylor driveway, which is far north, and then turning back out to the public highway. That's what that paragraph applies to. It doesn't have anything to do whatsoever with the piece of Spring Avenue shown on the 1939 map.
What piece of Spring Avenue would that be?
That would be the piece that runs from Ninigret north to the northern boundary of lot 66 on the 1920s plan.
You can put 6 aside,
Which is 6.
the exhibit in your hand. Those obligations that appear in the deed to grade and stake look similar to the obligations laid out in section 5 of the 1923 statute, don't they?
Yes,
You haven't studied aerial photographs of Spring Avenue extension in connection with your engagement, correct?
I have not.
Now, going back to the 1939 plat with the zoning board and highway commission stamps on it. I see you have that in your hand, correct?
Yes, sir.
This was recorded several months after the deed of Spring Avenue work for the town was recorded, correct?
Correct.
And you don't actually know who recorded the 1939 plat, do you?
That required that it be authorized by the owners of the property. So that it, according to the statute, it could not have been recorded if the owners did not authorize it.
But you don't know precisely who recorded it, correct?
I was not there. I was not even born.
At the time it was recorded, the town itself was the owner of Spring Avenue north of Ninigret, correct?
But the ownership requirement refers to the plat itself, and the town of Westerly surely did not own the entire plat.
I agree with you, but at the time the 1939 plat was recorded, the town was the owner of Spring Avenue north of Ninigret, correct?
Only to the northerly line of lot 66 that it showed on the plat. So there was a couple of 100 feet beyond that, heading further north, that at the time was owned by the Weekapaug Beach and Land Improvement Company. The deed to the town runs from where it's shown on Ninigret Avenue only to the north of 66 and cuts across there. So there's a portion here that was not owned by the town until the recording of this map.
Are you aware that in 1964, a plat was filed in connection with the Brentwood Estates neighborhood of Westerly?
No, sir.
Your Honor, committee, I have been sparing in my objections, especially on relevancy. But what's forthcoming is reference to a plat that, using Google Maps, is 5.2 miles away from the subject over in the Watch Hill neighborhood. Mr. Barside wants to make certain points about that other plat, I guess, as a demonstrative comparative. The trouble is that puts the proponents, especially my client, Caroline Contrada, in the awkward position of having to research potentially every plat of every subdivision in the whole town of Westerly, because the supposed counterexamples are going to be used against her case. And the fact is that each of these plats and each of these subdivisions has their own history. And it could be that whatever roads exist on these plats might have been abandoned, for instance, just to take a hypothetical. I'm not saying that they were abandoned in this case, but they could have been. Is my client, having spent so much resources already on this case, now have to expend further resources in going around and researching all of these demonstrative comparative plats from other parts of town? So I submit that to you by way of an objection as to the relevancy and admissibility. And I also point you to, I believe it's Rule 403, which says that albeit relevant, something can be excluded if it's too much of a distraction or diverts resources away from the main issue in the case. So on those grounds, I would object to, as to relevance, as to the Brentwood plat. I would add that if you're disinclined to grant my objection, then consider these arguments as to the weight. Thank you.
Thank you, Mr. Rubin. The subcommittee will consider those arguments as to the weight.
We make no apology for attempting to admit evidence that's counter to the arguments set forth by the proponents in this case. Now I'm going to hand to counsel a copy of Whitman Mark District Exhibit 3 here.
Thank you.
Thank you.
Mr. Priestley, I've handed you a document with Whitman Mark District Exhibit 3, the copyright in yellow. It's a 2-page document. You have that in front of you?
Yes, sir.
And the first page of the document shows what appears to be Round Hill Road and Montego Road. Do you see that?
Yes, sir.
Along with Ocean View Highway. You see that?
Yes, sir.
And if you turn to page 2, page 2 appears to show the same development and the same roads. Would you agree with that?
Yeah, it looks like a bad copy, but ultimately put together makes a single map.
And do you see? Okay, thank you. On the second page, and for the subcommittee, this is tab 3 behind the letter A of your binders. You see stampings with signatures, one by the zoning board, one by the Department of Public Works.
Yes, sir.
And the Department of Public Works of Westerly was the administrative body that succeeded the Highway Commission, correct?
Yes, sir.
Right, and this Brentwood Estates plat shows that it was recorded at the town, correct?
Yes, sir.
So in essence, this Brentwood plat has the same stamps and was recorded as the 1939 plat involving Weekapaug Point, correct?
No, it doesn't really. It has a similar zoning board stamp which says approved. But there's a serious distinction on the Department of Public Works. It says approved for road layout, which is a limiting factor which would come early in the process, as opposed to simply approved, which would come later in the process. So this would have been approved for road layout before the zoning board approved it. That's the ones that approved. It would have gone back to the Department of Highway Commissioners to actually then approve the roads themselves. This is only for layout, whereas the unlimited approval in 1939 would have been for the roads themselves.
But didn't you just testify that was the administrative body that succeeded the Highway Commission?
And there were 25 years between when one happened and the other. Procedures could well have changed. And in fact, that stamp is significantly and substantively different than the 1939 stamp.
Did that succession happen in 1959?
I don't know when it happened.
And the Brentwood plat is dated 1963, correct?
Oh, yes, it clearly was stamped, but it was clearly after it happened. It was the correct body, I'm sure, though I don't know it.
Okay, can you please refer back to the District Exhibit 1, which is the private road list we discussed earlier?
Objection for the reasons previously stated.
Noted.
I have.
Thank you. Now, if you look in the right-hand column, the third entry from the top in the list of private roads is Montego Road, correct?
Yes, sir.
If you look beneath that, Round Hill Road also appears, correct?
Yes, sir.
Objections for the reasons previously stated, if I may, so I don't keep interrupting. Each time there's a reference to this unofficial list of roads, I would like my objection to be noted for the record, so I don't keep interrupting council every time he refers to this list. If I may have a continuing objection, I would appreciate that. I think it would be convenient for the panel.
Yes, you may have that continuing objection. It'll be noted on the record.
Thank you.
Okay, thank you. Now, let's go back to Weekapaug. The later 1939 plat. Forgive me, there was a later 1939 plat that was recorded in 1941. Do you recall that?
I think so. I don't have it in front of me, obviously.
Okay, I'm going to show the witness Proponents Exhibit 9 and Proponents Exhibit 12.
Thank you.
handed the witness two documents. One is marked Proponents Exhibit 9 in red at the top, and the other is marked Proponents Exhibit 12. These can be found by the subcommittee in tabs 9 and 12 of your binder. Mr. Priestley, does this refresh your memory that there was a 1939 plat recorded in 1941 and a separate 1948 plat relating to Weekapaug?
I'm looking for the date. Yeah, March. Yes, sir.
Now, both of these plats have an insert showing the Spring Avenue extension, correct?
Yes, sir.
And the language on them states, quote, owners of lots shown on this subdivision have a right of way to the Atlantic Ocean over Spring Avenue extension shown as a 50-foot right of way on the insert plan, correct?
Yes, sir.
These two plats do not say the general public has a right of way over Spring Avenue extension, correct?
They do not.
And they do not say that the owners of the lots shown on the subdivision, along with members of the public, have a right of way over Spring Avenue extension, correct?
And they don't say that they have it along with the owners of the Mackenzie plat either, but they do.
So I'm just going to ask the witness to answer the question, which was they do not say that owners of the lot of the subdivision, along with members, have a right of way over Spring Avenue extension.
They do not.
And the witness is allowed to explain his answer each time he answers, please.
And Exhibit 9, which is the 1939 plat recorded in 1941, has the same stamps on it as the 1939 plat, doesn't it?
I think they do, but I really can't read the ones on your copy of the 1939 map, so I can't be positive.
Now, you're aware that there were 64 private easements over Spring Avenue extension given to various landowners within Weekapaug between the 1940s and 1965 or so, correct?
I'm aware that there were a lot given. I don't have the exact count. I would accept your count.
But neither your testimony on November 4th nor your expert report in this case addresses those private easements, correct?
No, mine stopped in 1939 when there was the dedication to the public. I actually went a little bit beyond that, but not very far. I think I went to 1947.
So even after the recording of the plats that you covered in your testimony on November 4th and we've discussed today, including the 1939 plat, the sophisticated developer, in your opinion, kept granting private rights of way over Spring Avenue extension over and over and over again over 60 times between the 1940s and 1965. Do I have that correct?
Objection. We have no idea what a sophisticated developer is. I would ask that to be some kind of foundation for that characterization, please.
The characterization is the witnesses.
I would say that the sophisticated developer and the sophisticated purchasers knew exactly what they were doing, and that despite the dedication to the public, if I'm buying a lot in one of these two subdivisions, I know that towns can abandon rights of way. I know that rights of way can be disputed. So I want a private right of way, and it has serious value, even if it's been dedicated to the public. If I was the buyer of these lots, if they're for the price they probably wanted, you'd have insisted upon it.
Please bear with me. So, Mr. Priestley, as of 1942, it's your view that the town had an easement in Spring Avenue Extension. Do I have that correct?
Yes, sir.
I'm going to hand the copy of the 1942 easement from the Army Corps of Engineers to opposing counsel, the proponent's counsel, and then to the witness. This is joint exhibit A. This document is not in the subcommittee's binder. Oh, sir, Joe, thank you. Thank you. Mr. Priestley, you recall there being an easement granted in 1942 to the Army Corps of Engineers to lay infrastructure for the purpose of national defense across Spring Avenue Extension?
Yes, sir.
And your testimony on November 4th did not address the 1942 easement given across Spring Avenue Extension by the Weekapaug Beach Company, correct?
Correct.
If the Army Corps of Engineers wanted or needed to dig up part of Spring Avenue Extension to lay defense infrastructure in 1942, that necessarily would have interfered with the town's right-of-way that you claim existed as of that time, correct?
Only temporarily and perhaps not entirely. It was a 50-foot right of way. They probably wouldn't have used the entire thing.
Would have the Army Corps of Engineers have at least needed a permit or some other acquiescence from the town that the town's surface rights to use that allegedly public right-of-way could be interrupted by the Army Corps?
I don't think they would, but if there were, I don't think they would.
You're not aware of the Army Corps ever obtaining such a permit or other acquiescence from the town?
I haven't followed anything but the Army Corps of Engineers related to this property.
You can put that exhibit aside, please. Now, as part of your job as a title agent, you make decisions on which parcels are able to be insured, correct?
Yes, sir.
You've probably issued a couple thousand title policies in your career, would you agree?
Give or take, yeah.
And in your capacity as a title agent, you would not insure the town's current interest in Spring Avenue Extension, whatever that interest may be, correct?
Not with this litigation pending, but I'd get fired as an agent.
So let me try to sum up your position here. It's 1939. The sophisticated developer first in February 1939 deeds Spring Avenue north of Ninnegrit. We agree, not Spring Avenue Extension, to the town, correct?
Yes,
So the developer is capable of deeding a road to the town. In other words, clearly knows that's an option, correct?
if the town's willing to accept it.
But instead of deeding other roads or ways, including Spring Avenue Extension to the town, your contention is that the developer wanted to give an easement over those roads and ways with a much less direct approach of recording a plat that was stamped by the Zoning Board of Highway Commission, correct?
Whether they wanted to or not, they did, may have been required by the town as a condition of accepting Spring Avenue.
Now, the plat nowhere says on it that it's a dedication of anything, correct?
No, it doesn't say it.
Now, you were aware of a 1940 Westerly Town Council report on right-of-ways to the shore in Westerly, correct?
Objection.
I haven't moved to put a document in yet.
Oh,
I suggest the objection's not right.
I'm going to object to a reference to a document. And since it's been mentioned by counsel, I'm going to object now.
Understood. So, Mr. Parside, could we lay a little bit of foundation for that?
Thank you.
Well, as part of the witness's testimony on November 4th, Mr. Rubin was the one who brought up the issue of the 1940 report to the witness and asked a couple of questions about it. So I don't see how I would be barred from actually introducing the document or examining the witness on it. Beyond that, the 1940 report is relevant and probative. It's an ancient document. There's really no reasonable controversy. It's certified by the town clerk. It was obtained, we understand, by the town itself from the Judicial Record Center and includes a list of rights of way in Westerly as of 1940. So I can't really imagine more probative or relevant document that's been authenticated, that was raised. The door was open to this testimony in Mr. Rubin's direct examination of the witness.
Actually, I objected to the reference to that document at that point in time too, as board may remember. Despite the representation that it's authenticated, it actually is not authenticated. The document sought to be admitted as I think conceded by Mr. Farside's reference that it's authenticated must undergo some kind of authentication. We can't just, although the rules, strict rules of evidence may not apply, we can't engage in rank speculation or random documents that somehow reference rights of way from the 1940s. Now, while I understand that we don't strictly follow the rules of evidence, we are informed by them. And implying and applying those rules, while it's fine to say on some occasion, you take them in to consider what they are worth, at some point they have no worth whatsoever and should not be considered, should not just simply balance the weight of them. They should be denied admissibility altogether. Now, the process to show that a document, and I would point to Rule 901A of the Rules of Evidence as a guide for what I'm about to discuss. Pursuant to that rule and pursuant to Rhode Island Rule 9024, certified copies of public records may self-authenticate. However, the rules require that certain standards be met before we can call them authenticated. The 1940 report does not self-authenticate. Self-authenticate under the rules of evidence, and I commend you to 9024A, a document, quote, must be a copy of an official record or report authorized by law to be recorded or filed, and actually recorded or filed in a public office, certified as correct by the custodian or other person authorized to make the certification. None of that foundation has been provided to you. It's just sort of pulled out of the air and said, here, let's use this. A photograph of a document purporting to be a certified copy is not a certified copy and does not meet the requirements of self-authentication. The exhibit is also not authenticated pursuant to 9024 because the document is not a complete copy of the 1940 report. As you know, there's been extensive discovery in this matter. We've all exchanged documents with each other. We know what this document looks like, and it is not a complete copy of the 1940 report. The document does not include the record of meetings held, which was incorporated. Our Rhode Island Supreme Court, in cases regarding exemplified copies of court documents, have noted that, I'm going to quote, when a copy of a judgment is an incomplete copy of the proceedings or lacks either the requisite authentication or seal of the court, it should not be admitted into evidence and considered by a trier of fact. That's what you are here. You are the triers of fact. Our Supreme Court says, based on the face of this document, that you may not consider it. And that's from Frazier versus Pettit, 509 A. 2nd, 998, at page 1001. It's a 1986 Rhode Island Supreme Court decision. It's important to have a complete document. Common sense tells us that, but the Supreme Court has affirmed that for us. Why do you want a complete document? Because a complete document informs and allows the trier of fact to understand what the record means rather than guess or infer. And guessing and speculation and frankly, negative inferences are what's going to be the purpose of introducing this document to you. Our rules state that a duplicate is accorded the same evidentiary status as an original unless an issue is raised as to the original's authenticity, and that's in Rule 1003 of our Rules of Evidence. Pursuant to Rhode Island General Law 38-3-5.1, a reproduction of a document, quote, when satisfactorily identified, shall be admissible in evidence as the original in any judicial or administrative proceeding. So this is the rule pursuant to statute that applies to this proceeding. So this is one of those cases in which, frankly, the committee can't just say, well, let's just let it in and give it the weight it deserves. There's a statute directing you that you can't receive this document. 38-3-5.1. I'll read it. When satisfactorily identified shall be admissible in evidence as the original in any judicial or administrative proceeding, whether or not the original exists or is available, and an enlargement or facsimile of the reproduction shall be likewise admissible in evidence if the original is in existence and available for inspection under the direction of the court. None of that statutory requirement is met here, which applies to administrative proceedings. In this instance, you'll see that the town clerk is unable, the current town clerk is unable to locate the so-called 1940 report in town records. This raises a very legitimate question as to the proposed exhibit's authenticity because it cannot be replicated now and certified as required by 9024. It's also clear, quite frankly, that when you see the document, it's been altered in part. An incomplete and altered document. It appears with a typed Exhibit B at the top. And it is on the same legal paper that the answer was on exhibit. This leads to the conclusion that someone has typed the document or perhaps asked someone at town hall to retype the document onto a legal paper. I'm speculating by how that could have happened, but we do know that it's incomplete and it's an altered document. The typeset of the clerk's proposed certification is different. It's different than the typeset used throughout the document. There are very legitimate concerns about the completeness and authenticity of the document. Notwithstanding those evidentiary problems under the rules of evidence and in accordance with the statute that applied to administrative hearings, the 1940 report is irrelevant. Its admission at this point would do nothing then to lead to confusion and built upon what we now see are a series of negative inferences regarding the evidence and the opinion of this expert. It's pretty basic. 402 tells us that relevant evidence is admissible, and evidence which is not relevant is not admissible, even under the relaxed standard in front of an administrative panel. Relevant evidence, let's go back to first principles. Let's see what relevant evidence really means. Let's remind ourselves of that. Is evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without that evidence? So while understanding in an administrative proceeding with the relaxed rules of evidence, every once in a while it's good to remember first principles and what relevant evidence really means, what's probative and what's not. That very clear, lucid explanation that, from Rule 401 tells us that this 1940 report is not admissible. an incomplete document that was attached as an exhibit. I mean, twice removed, maybe 3 times removed from authenticity. It is an incomplete document attached as an exhibit to an equity action regarding different rights of way. Doesn't have anything to do with Spring Avenue. Doesn't mention Spring Avenue. Now, the district seeks to admit this document to prove a negative inference, as I just said a moment ago. We're now starting to collect negative inferences, and you can see where this is going. You're going to be asked to build one negative inference after another. Spring Avenue was not included, so therefore it's not a right of way. That's what they're saying, right? It's this incomplete, altered document from 1940 that doesn't include Spring Avenue. So Spring Avenue isn't a right of way. That's where we're going with all this. If you really want to go down that road. Without knowing, the committee's definition of a right of way, the scope of their investigation and records of their findings from whatever that proceeding was in that equity court at that time, it's impossible to know if Spring Avenue extension had anything to do with that equity action. Impossible. It's not known what rights of way the committee was charged with investigating or what they defined as a right of way. So not only do you not know what the equity action was involved in, you have no idea of what the scope of this committee report was meant to be. Again, it just pulled out as an isolated document, as incomplete and altered as it may be. Suggest to you that admission of incomplete and all altered documents would really reasonable inferences, not negative inferences, reasonable inferences should be based on facts, not speculation and conjecture. There's lots of grounds of big court cases that tell us that. Findings must be made on some kind of competent evidence and proof. Without the missing pages, the definitions used, and the amount of research performed by the committee will never be known. Without that information, you will be left with rank speculation as to the meaning of that document. So if after thinking about this, the document, the committee wants to consider the admissibility of that document, then significantly more foundation must be made before it can be used by the fire district for any purpose whatsoever.
Mr. Parside, do you have any further response to that?
Absolutely. And I appreciate Mr. Conley pointing out that the obvious, which is the lack of Spring Avenue extension appearing on this document, makes it perfectly relevant and probative. There's really no reasonable controversy on the authenticity of it. Rhode Island Rule of Evidence 901 says evidence that's either a public record or an ancient document more than 20 years old or self-authenticating documents that are admissible if relevant. This document has the words on it. Well, first, it was produced to us by the town in this very litigation, has the words on it, a true copy of a report on file, the town clerk's office, attest, Lawrence L. Solovitzik, deputy town clerk. To the extent that Mr. Conley wants to dispute that this is the precise copy of the 1940 report, I submit that he is now the one putting facts, not in evidence, before the subcommittee, wondering aloud about where certain changes to a document may have occurred. They've had this document since since December 30th, and this is the first time we're hearing any articulation of their objections there too. The fact that it was certified by the deputy town clerk, that it was produced to us by the town, that it's a listing of rights of way in Westerly as of 1940, the fact that we have newspaper articles that confirm that the committee was formed in 1939 and carried out its duties in 1940, I'm sorry, was from January of 1940 and carrying out its duties through August of 1940 are enough to confirm the authenticity of this document. We'll put those newspaper articles in the record if necessary to do so. But I once again remind the subcommittee, this issue was raised by Mr. Rubin at his direct examination and Mr. Priestley on November 4th. We have every right now to put this report before this witness and ask him questions about what it may mean to his opinions in this matter.
So I think that there have been a lot of arguments just put on the record on this particular issue. And I'm going to stick with the earlier point that was made, which is the subcommittee has now heard all these arguments and that they can apply those arguments to assess the weight of that document. And that's not making a judgment on the authenticity of the document. And it's not making a judgment on the completeness of the document or the accuracy of the document. It's just a matter of considering those arguments that were made just now and giving the document the weight it's due based on those arguments. Considering the significance and the push of these arguments, is the subcommittee inclined to have a vote on whether or not to admit? And my recommendation would be to have the document admitted as the rest of the documents have been and give them their due weight, and then they can be considered de bene at that point. Is a vote necessary? Okay, no vote is necessary. Again, it will be admitted and given the weight that it's due based on those arguments. And at a different point, council can make further argument on this particular document, as we've previously discussed.
Thank you. Appreciate you listening to our arguments.
I'm now going to hand a copy of what the Mark District Exhibit 7 to proponents council.
Are you able to pause right now and we can take our break right now?
That's fine, Mr. Chairman.
Okay, we'll take a 10-minute break. If everyone could just be seated, we'll recommence. Good, Cindy? All right, we're back on the record. Attorney Farside, you're up.
Thank you. I'm going to show the proponents council a copy of what's been marked District Exhibit 7, 1940 report. Mr. Priestley, you've seen this report before today, correct?
Yes, sir.
And do you recall that engineer Louis J. Rossi was on the committee that authored this 1940 report?
Yes, sir. And his signature is at the bottom of page 2.
And the 1940 report was authored by the committee and presented to the Westerly Town Council on August 5th, 1940, correct?
It's dated August 5th, 1940.
The document in your hand is dated August 5th, 1940.
Yes, sir.
And August 5th, 1940 was less than a year after the 1939 plat that you rely upon was recorded in October of 1939, correct?
Yes, sir.
And the report lists a number of right-of-ways to the shore of Westerly, correct?
Yeah, and it's a report to the town council for action by the town council. It doesn't have any effect of its own except for to advise the council.
Where does it say that it's for action by the town council?
You don't have the complete report. There was a subsequent meeting where there was action taken on it by the council.
And is that something that's in your expert report?
No, it was in some of the discovery that I was given along with this. This wasn't in my report either.
Now,
And it also says at the top, to the Honorable Town Council, Town of Westerly.
Thank you. And the document states that the right-of-ways to the shore were found following a, quote, thorough and painstaking effort to clarify as far as may be the situation relative to claimed public rights of ways to the Atlantic Ocean and tidal waters within the town, correct?
Yes, sir.
And the list of right-of-ways in this 1940 right-of-ways report does not include Spring Avenue Extension, correct?
Which is very interesting because what it does include is every right of way on the Everett plat of Watch Hill that was recorded in 1886, the B. Frank Hart plat of Cottage Sites just north of heading from Watch Hill towards town, recorded in 1903. The Saunders Atlantic Avenue plat recorded in 1912, the Saunders Pleasant View plat recorded around the same time, and the Misquamicut Pleasant View plat, which is all in Misquamicut Beach. As it's reporting to the council, it includes all of those, every right of way shown on those plats as incipiently dedicated, and leaves out only one, which is the incipiently dedicated right of way from 1920 on the Mackenzie plat. And since it's the reporting to the town council of potential rights of way, it would be completely irresponsible simply to leave out the only one on a map abutting the ocean, only one, which is the Beach Avenue extension on the Weekabaug Beach 1920 plat. And so the only reason I can see for them doing that is because Mr. Rossi knew that it was already dedicated to the town and therefore didn't have to be reported to the town for further action.
So the list of right-of-ways in the 1940 right-of-way report does not include Spring Avenue Extension, correct?
It does not.
And the report does not use the word incipient dedication, the words incipient dedication anywhere, correct?
It does not.
Okay, so the 1939 plat or plan that you rely upon as dedication and acceptance was authored by or revised by Rossi and Lewis engineers, correct?
Yes, sir.
And it was recorded in October of 1939, correct?
Yeah, there's no doubt that Rossi knew about Spring Avenue extension.
And it's your understanding that Mr. Rossi was a principal, that Louis J. Rossi was a principal of Rossi and Lewis engineers, correct?
I don't know it, but I'm pretty sure he was. I think he was.
So in 1939, Mr. Rossi's plat is recorded, and then Mr. Rossi was appointed a couple of months later to this right-of-way committee by the town council, correct?
Yes, sir.
And 8 months after that, in August of 1940, Mr. Rossi and other committee members list out the right-of-ways to the shore, correct?
They list out every platted right of way to the shore from Watch Hill to Weekapaug with one exception. That one exception is what we've been calling Spring Avenue extension.
And you agree that Mr. Rossi would have been well aware that the 1939 plat had dedicated Spring Avenue extension to the public and was accepted by the stampings and signatures on that document, correct?
Which would be the only reason I can understand him not including it in this report, because this report is basically reporting to the council for subsequent action by the council accepting the rights of way listed. If that had needed to be, it would have been irresponsible not to mention that right of way in this report had it not already been accepted and had he not already known that.
So to try to sum that up, it's your position that it was so obvious that Spring Avenue extension was a right of way to the ocean, it didn't need to be included on this list. Do I have that correct?
It was so obvious to Mr. Rossi, yes.
But the 1940 report nowhere states that it's only a list of dedicated but not yet accepted rights of way, correct?
The subsequent action, the council instructs the zoning board to take the necessary action to accept them.
And where's the evidence of that subsequent action by the council?
It's another council meeting in the chain of meetings which you haven't given me.
I'd like to note for the subcommittee that the witness appears to be referencing a document that was not produced to us in discovery. We reserve the right to obtain that document in discovery and, if necessary, to re-examine the witness on that document. But for now, we should move forward with this particular examination to its conclusion. But we have serious reservations that there may be a document that was not provided to us despite the extensive discovery in this matter. The 1940 report, Mr. Priestley, nowhere states that it is only a list of possible or potential rights of way to the shore, does it?
It says claim public rights of way, which claimed, in my opinion, would imply that they were possibly rights of way, that they were claimed by somebody.
So as far as you're concerned, the 1940 report, which does not list Spring Avenue extension as a right of way, somehow makes it more certain that Spring Avenue extension was a right of way as of that time. Do I have that right?
Yes, I think Mr. Rossi would have been completely irresponsible not to list that, since he knew it was platted, he knew it was a potential right of way to the shore, and it's apparently what the committee was charged to do, was to represent to the town all potential rights of way to the shore for action by the town.
Okay. The 1939 plat made Spring Avenue extension public because it showed Spring Avenue extension and is stamped by the zoning board and the highway commission and was recorded, correct?
Yes.
And it does not matter that Spring Avenue extension was never deeded to the town, correct?
No, it doesn't matter.
And it doesn't matter that Spring Avenue north of Ninnegrit was expressly deeded to the town in that same year, correct?
Correct.
And it doesn't matter that the 1940 report to the town council nowhere lists Spring Avenue extension as a right of way to the shore,
Well,
correct?
as I said, I think that makes it more likely rather than less likely.
And that is true, even though one of the 1940 report authors was the reviser of the same 1939 plat you rely upon, correct?
It's true, especially because of that. You might be able to say, if it hadn't been for Mr. Rossi, that they just missed it. But in this case, they didn't just miss it.
And it doesn't matter that the United States government, through the Army Corps of Engineers, obtained an easement over Spring Avenue Extension in 1942, not from the town, but from the Weekapaug Beach Company, correct?
The Weekapaug Beach Company, who and its successors remains the fee interest owner of this strip of land of which the town only has the right of way.
And it does not matter that later plats have an inset reserving the use of Spring Avenue Extension to owners of lots shown on those plats, correct?
No, it doesn't matter.
And it does not matter that between 1939 and 1965 or so, over 60 private easements were given over Spring Avenue Extension by the developer of those lots, the Weekapaug Beach Company,
In
correct?
fact, those were really identical to the ones that you just mentioned showing the inset. There were the lots in there, people buying from the developer.
Are you familiar with the statutory framework regarding abandonment?
Yes, sir.
Are you aware that the abandonment process only extinguishes public rights?
Yes, sir.
You agree that abandonment would not extinguish private rights that would exist based on the recording of plats, correct?
Which is why you want to have the private rights as well as the public right if you're buying those lots, because an abandonment could terminate you if you only had public rights, but your private right would remain.
And you're not aware of a single deed, plat, or other document that expressly identifies the Spring Avenue Extension as a public way, correct?
Correct.
But despite all these things, it's your opinion sitting here today, the Spring Avenue Extension was made to be a public right-of-way in 1939. Do I have that correct?
Yes, sir.
I'd ask for a 2-minute recess so I can consult with my co-counsel
Okay,
before concluding. Thank you.
you're welcome.
So.
Mr. Chairman, I do have just a couple more questions before I conclude.
All right, just hang tight 1 second because I just want to make sure we afforded them an opportunity. They confer. You guys good?
We have 1 more minute?
Yep.
I appreciate that.
That's
Thank you, Mr.
okay.
Chairman. Thank you, Mr. Chairman. Appreciate that.
You're welcome. You may proceed, Attorney Forsythe, if you're ready.
Thank you, Mr. Chairman.
You're welcome.
Mr. Priestley, can I ask you to look through the stack of exhibits there? On exhibit marked District's Exhibit 3, which is the Brentwood Estate plat.
Oh, thank you. I have it.
Now, do you remember testifying earlier tonight about this document?
Yes, sir.
And this document bears the stamp of the zoning board, correct?
It's approved by zoning board, and then I think it's May 20th, 1964.
And it says approved for road layout, Department of Public Works, and it's signed as well, correct?
Yes, sir.
And you can see that this document was recorded, correct?
Yes, sir.
But you agree that all the roads shown on this document appear on a private road list, which is District Exhibit 1, correct?
Objection to the reference to the private road list for the reasons previously stated.
Noted.
Thank you.
Yes, sir.
Thank you. I have nothing further at this time, other than to reiterate our need to get discovery from the proponents on the issue of subsequent reports for the town council in connection with the 1940 report. Thank you.
I think that there's a misunderstanding. I think the witness is referring to the minutes of the town council itself. In other words, the town council received the report on the same date as the date of the report. Those minutes have been provided. I'm going through my documents now. I'm quite sure they were provided in any event. They were certainly available. The minutes are available to anybody. So I think that there may be a misunderstanding. I don't think the witness referred to a subsequent report. I think the witness is referring to the action of the town council on the in passing a resolution accepting it. I'm quite sure that that material was furnished. This all came about because Mr. Farside produced something that he characterizes as a smoking gun. I don't say that facetiously or sarcastically or anything like that. And then we undertook to look into it. And even though it was our own work product, we turned over everything to Mr. Farside, including the copy of the report that he's using. So there hasn't been any reluctance to provide discovery. I have to look through my files to find it exactly, but I know that that's what happened.
Okay.
So if I may, on behalf of the town of Westerly, given the last question by Mr. Farside, the town now will voice its objections to the reference to that 1964 Brentwood plat. We now know, based upon the questions of council and most especially that last question regarding the Brentwood plat, that it depicts an area near Watch Hill in the town of Westerly. It's in a separate part of town from the Spring Avenue case and doesn't inform us at all about any of the evidence before you regarding the what we referred to as the Spring Avenue extension. So the real issue on admissibility now has become if it is considered by this panel, it's going to put the burden on the town of essentially opening an inquiry into unknown matters that would be needed to clarify the meaning of the Brentwood plat in order for this committee to reasonably rely on it for the comparative analysis that we now understand for which it's being offered. There are significant lacks of facts that give this document any relevance in regard to this proceeding. The Brentwood plat might have been done and stamped prior to the road construction based on the testimony from the witness and his review of the exhibit. The DPW stamp might have reflected a mere a priori preview of the intended roads and not a certification that they were built accordingly. That's the testimony we have on the record at this point. We now know that it's probably not an as-built approval, that for DPW, it looks like it was a merely provisional approval. Indeed, we now know from the exhibit itself and the testimony of the witness that it suggests by its very wording, quote, approved as to layout. So it has absolutely no level of relevance to anything that has anything to do with Spring Avenue being a public, that portion of Spring Avenue being a public right of way. A few minutes ago and addressing, that there should be some threshold for relevance admissibility in the committee. I cited to rules of evidence. I won't do that again. But I suggest that this exhibit, now that we've heard this testimony, doesn't come close to meeting the threshold of admissibility. In fact, what the rules of evidence tell us that it should be excluded. It's to cause the parties before you to engage in that kind of investigatory work and present it to you later in the hearing really is a waste of time. You don't need to do that. We will need to do it if this remains in evidence. Because we can't allow it to confuse the record with, yet again, another multiple negative inference, not reasonable inferences. Courts have told us that investigating, litigating complicated underlying sources of profit comparative evidence often leads to waste of time, confusion for the fact finder, and in such circumstances unfairly prejudices the opponent of the evidence. And we cite to you Burlington N.R. Company versus the Washington Department of Revenue, the 23rd F3rd 239 at page 241, a 1994 decision of the Ninth Circuit. That was a case involving evaluation of a railroad company's property in one particular state. And the Ninth Circuit held that the court did not abuse its discretion in excluding exactly this kind of comparative evidence. So I want to provide one other example for you for the record, and it's Wyninger versus New Venture Gear Incorporated. That's a Seventh Circuit case. Again, holding that this kind of profit comparative evidence that requires significant underlying investigation to show its admissibility and allow a fact finder to rely on it for reasonable inferences should be excluded. And finally, based on the fact that we now know from the testimony that the Brentwood plat is dissimilar to the Spring Avenue plat in location, epoch, genesis, and administrative oversight, it should also be excluded. And for that proposition, I cite you to United States versus LZ, ELLZEY, a 936 F2nd case, 492 at page 497. It's a 1991 10th Circuit case relying on the Federal Rules of Evidence 403, which is essentially our same Rule of Evidence 403. So for all those reasons, I would ask you not to exclude that document and to exclude any testimony relating to that proposed exhibit. Thank you.
Attorney Farside, you could,
I was just going to say, Julia Harvey for the Attorney General's office. We also adopt the objections that the town has offered with respect to both the Brentwood plats and the 1940 report.
I would just incorporate by reference all of what Mr. Conley said with respect to the Brentwood plat, and adding, of course, to the extent that the council just inclined to disagree, that the arguments be taken to go to the weight of it, it would put an unfair burden on Caroline Contrada and the other proponents to have to research the whole history of a distant and remote plat. Thank you.
Mr. Farside.
Thank you for the opportunity to respond. The district has been placed under an undue burden by this entire process. So the fact that the district is able to locate plats that have the same or substantially the same stampings as the magical 1939 plat and has roads that continue not to appear, roads that continue to appear on the private road list of the town of Westerly is highly relevant and probative. The document itself is a recorded document that we located that shows once again that the stampings relied upon by the proponents don't effectuate the dedication that they claim it does. So I understand the proponents' desire to exclude any document that doesn't fit their narrative. Unfortunately, we have the opportunity to defend ourselves, and we'll continue to do that. It does not cause any undue burden on the other side that we have unearthed this evidence. Thank you.
So I'll again repeat myself. The arguments are noted on the record, and the evidence can come in, and again, the arguments go to the weight of that evidence. And that's that.
Thank you for considering our argument.
Thank you. Any further questioning of the witness? Redirect or?
I would have redirect. Thank you. Mr. Priestley, do you recall the portion of your cross-examination in which you were referred to language in the February 1939 deed that concerned in consideration of the fact that the town hereby accepts, and goes on to talk about the need for highway commission approval?
Yes, sir.
Okay, you remember that portion of the testimony? And what I would like you to do with respecting all the wires that are on the floor in front of the subcommittee, and not meaning any disrespect to the subcommittee, I'd like you to circle around in back of the subcommittee so we can approach the easel, and I can hand you a pointer, a laser pointer. Would you mind walking out there and?
Excuse me, Mr. Rubin.
I can do the front. I can.
Would it be preferable to have the easel moved here? I don't know.
Whichever,
If the subcommittee-
There's 3 items there.
Did he call me the mountain?
Right? Closer, just the mountain to Muhammad or Muhammad to the
Mr. Gagnon, if you'd let us know whether that's an acceptable location for you two, Mr. Reynolds.
Can I hand you the laser pointer? Okay. Now, there's a little, and it comes out this end, yeah, so I won't show it. So go this way. All right. Now, you need me to show you the item, which is, exhibit,
If you're talking about the deed, I have it in front of me.
you have it in front of you, okay, and, I think that you'll agree that it's, exhibit J, also identified, as, has also been identified as exhibit 6.
I don't know.
You don't know that.
There is
No.
an exhibit number, but what it is the deed from the Eagle Beach Company to the town of Westerly.
Okay.
Recorded in book 58 at page 519 of the land record.
Okay, and, would you slowly, surely read,
This is number 6.
the
found it too. You got that?
paragraph in question we've been getting as a part of the,
Yes.
and continue, to the end of that paragraph.
As a part of this deed, this is after the description of the property that was conveyed. As a part of this deed, and consideration of the fact that the town hereby accepts the land hereinbefore described, hereinbefore conveyed, for use for highway purposes. And in order to provide for future, so that Spring Avenue will not be a dead-end street, so-called, the grantor agrees to dedicate as a continuation of said Spring Avenue as above described for use for highway purposes, a strip of land 50 feet wide to be staked out at the extent of the grantor, the location and grade of which shall be subject to the approval of the Highway Commission of the town of Westerly. Said strip of land to join and abut the above described parcel, a parcel that was conveyed, or Spring Avenue on the south, and to extend and continue northwesterly west of that portion of Quannacontog Pond known as the Mud Cove, and northerly to the present existing laneway leading to the former Taylor farmhouse, which is somewhere up in the sky there. And thence to turn and continue westerly along said laneway to the Weekapaug Heights Road, so-called, that Weekapaug Heights Road or highway leading from Shore Road southerly to the Atlantic Ocean, the approximate distance from the hereinbefore described northern terminus Spring Avenue And the laneway leading from Weekabaug Heights or High Road or Highway to the former Taylor House being approximately 1,450 feet more or less measured in a straight line. This agreement is to run with the land last described, and the agreement is binding on the grantor and its successors and
I think
assigned.
that's good enough.
And it's part, and said strip of land, the part just described here, running north, shall be staked out within a reasonable time from the time of this deed or at such time as the grantor shall be requested to do so by the Highway Commission of the town of Westerly.
Now, using the laser pointer, would you, going to, that placard, which, is a, blow up of Exhibit L, also known as Exhibit 7, which I think you will agree with is the 39 plat. Would you outline the area that Tim's talked about in the portion that you just read? There you go.
It begins right here.
Right.
And runs north and runs north and curves ultimately to the west.
To the west, yeah. Okay, so, is all of that represented on, that plat, which is?
Most of it is not represented on this plan.
Thank you. And so, looking towards the bottom of the plat, I think you'll agree that we find the highway commissioner's, stamp, or endorsement. It's,
Yeah, it's
Right.
there. It says approved.
okay, good. All right. And what is the relationship between that approval and the portion that you just read?
That approval approves what's on this map. Portion I read is what's off this map heading further north.
Okay, so there is no relation.
None.
Okay, thank you. Now, I can, approach the witness. I think that you'll agree that this is the earlier, 1920 plat recorded in 1921, correct?
Yes, sir.
Okay. Now, it's your testimony, well, is it your testimony that constituted the recording of that plat and with deeding out therefrom constituted an incipient dedication to the public of the roads on that plat?
Yes, sir.
Okay, did it constitute a completed dedication at that time?
No, sir.
Okay. What about the private lots on that plat? What rights did they have under that plat
Look, they have the right to use all the roads shown on the plat
as a private easement?
as a private easement.
At certain point in your testimony, and I believe that it was in the testimony regarding the 1940 report. I might have it wrong, but in the heat of the questioning, you referred to something as Beach Avenue extension.
Oh, I meant Spring Avenue.
Okay. I want to clarify that. I don't want to interrupt Mr. Parsons, but that was it's a technical error. Mr. Farside asked you if you would ensure the town's title to an easement at this point in time, or if you would underwrite such a policy or.
Title insurance companies do not like to buy litigation.
Right.
There's litigation on this.
Right.
Nobody's going to insure this.
By the same token, would you recommend to a title insurer that they insure a policy or issue a policy or underwrite a policy that the Weekapaug Fire District owns Spring Avenue extension free and clear of any public easement?
No, for the same reason. Subject to litigation. They're not going to buy that. They're going to wait till you finish it up. And then they're going to insure what the court tells you they have.
Do you have in front of you the item which is the 1923 statute, which occurs as
Chapter 538 approved June 13th, 1923.
right, which is Exhibit 5.
Got it.
Okay. And I'd like you to turn to Section 5.
Yes, sir.
Now, just very quickly, I know we've gone over this both on direct and cross, but very quickly, can you just summarize in a sentence the overall import of Section 5?
Section 5 provides a mechanism, the whole statute seems to provide the mechanism by which the issue of acceptance of a dedicated right-of-way can be resolved without having to provide further testimony.
Okay, and but Section 5 in particular are requirements for a particular right-of-way in terms of its quality in order to be accepted. Would that be fair?
Yeah, there are requirements that would have been acted on by the Board of Highway Commissioners.
Okay.
And would have been, had to prove to the satisfaction of the Board of Highway Commissioners at the time this was before them, which was in 1940.
Or 1939?
39, excuse me.
Okay. But can you read the out loud? Can you read slowly but surely the very last sentence of Section 5?
Until the provisions of this section shall have been complied with, and until such street or way is reasonably safe for travel, the Board of Highway Commissioners may close the entrance thereto from a public street.
Okay, and when it says the provisions of this section shall have been complied with, that's a reference to Section 5 itself, correct?
Yes, sir.
Okay, are there any provisions of Section 5 that are exempted from that requirement?
No, sir.
Okay, and by the way, the deed to Upper Spring Avenue, which was done back in February, or recorded back in February of 39, did that deed have to satisfy the provisions of Section 5?
No.
Why not?
Town already accepted the deed, and it was, and they had the right to do so.
So it wasn't under Section 5?
It wasn't under Section 5, no. 538, you mean.
Oh, Section 5 of 538?
Yeah.
Okay, so that would be an advantage of using a deed, is that you wouldn't have to go through these hoops, right?
I suppose.
I'd like to confer, if I may.
So we can spin up too. They can be fair.
Yeah.
I don't like another half hour. Few bucks for you guys.
In there, yeah. When it gets like that, I guess. I think it makes sense, right?
We're all set. We have no further questions.
Okay. Attorney Fawcett, any quick follow-up, Cross?
A bit of quick follow-up, Mr. Chairman, if I may. I'd like to approach and use the blue placard that was
That's fine.
given to the witness. Pardon me, Mr. Priestley. Our dueling pointers here. This exhibit shows some highlighting.
Yeah.
On Spring Avenue as it runs north of Minnetonka. Do you see that?
If I could,
And is it your understanding that that highlighting appears on the copy of this plat that's located in the land evidence records?
yes, it does.
So when this plat was recorded, someone undertook to apply this highlighting, this yellowish color to this part of Spring Avenue north of Minnetonka, correct?
Probably before it was recorded, that was presented, I would assume.
Thank you for that clarification. And just so we're clear, the 1939 deed, Spring Avenue north of Minnetonka, doesn't just address Spring Avenue north of this plat. It also addresses and deeds to the town this highlighted portion of Spring Avenue, correct?
Not all of that highlighted portion. That highlighted portion from here to here is included in the deed, but it stops at the northerly boundary line of lot 66.
Thank you. I have nothing further for the witness. I appreciate the witness's time very much.
Thank you.
Nothing further.
All right, you're all set, Mr. Priestley?
Thank you.
Unless you had questions.
No,
Oh.
we were just going to say the proponents would next call as a subsequent witness, Alfred Fiorio, but wanted to confirm that the committee wanted to meet with the next witness.
Yeah, we have
Great.
half an hour.
Request a couple of minutes for us to get set up.
Fine.
Joe, these yours?
Although we should hand in the district, we should hand you the newly exhibits that were shown to the witness tonight on behalf of the district. We should hand those to you.
Yeah.
Okay.
Are those those are all the ones that we've shown, or was were there?
But a lot of these are proponents exhibits that are already in the record. I just didn't want to duplicate those.
Okay, got it. Yes, that makes sense.
Okay, so let me just pull out the district exhibits and we'll hand those. It's only going to be 4 or 5.
Yeah, I think you guys got.
Thank you.
Careful. Or,
Well.
Good evening.
The microphone is off right now, but just before you start to speak, hold on. The answer is for you. Then the top. You might be. Why not? Like.
the above part. It's just kind of, in general, as a proponent.
Go west. They want.
Okay.
They kind of. They have trouble understanding. The town. That. Bill is.
Great, and just as we're getting set up, I have copies of the exhibits for Mr. Diorio's testimony for reference point for members of the committee.
Okay.
Thank you.
Thank you.
There you go. Thank you. Of course.
Is that an extra though? For the file, thank you.
Perfect. 4 total exhibits here.
Excellent, thank you.
Thank you.
So, Chair, please. Yeah. Mhm.
Just this one, you all hear me? Just this one more housekeeping matter. So the exhibits that I provided to members of the committee are additional. They're cumulative with the joint exhibits that have already been provided, as well as proponents exhibits 1 through 17. So I will be referring to some previously submitted exhibits as well. And so if anyone doesn't have any of their copies from last time, I'm happy to provide them.
Thank you.
So, Ms. Ari, just to be clear, these going along with the joint exhibits, these are submitted solely by the proponents and have not been yet reviewed by the
That is correct.
Fire district?
These have been, well, they have been reviewed. They were submitted electronically on December 26th.
Thank you. Mr. Dury, I'm going to swear you in before we get going. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? And would you please state and spell your name for the record?
Alfred W. Diorio, Alfred A-L-F-R-E-D, middle initial W, Diorio, D-I-O-R-I.
Thank you, Mr. Diorio.
Good evening, Mr. Diorio.
Good evening.
Would you please share your profession and current business address with us?
I am a professional land surveyor, president and principal of Alfred W. Diorio, RLS Inc., offices at 264 Woodville Road, Hopkinton.
And how long have you been a land surveyor?
Since the late 70s.
Do you hold any professional licenses or certificates in your field?
Yes, I do. I'm a professional land surveyor in Connecticut, Rhode Island, Massachusetts, Vermont, Germany.
And do you hold any other certificates?
I do. I have certifications as a certified floodplain manager, erosion control specialist, and a designer with DEM.
And can you tell us about your educational background?
Technology certificate from what was Hartford State Technical College.
And did you pursue any other training in furtherance of your career as a land surveyor?
In Rhode Island, professional land surveyors are required to undergo continuing education, so I fulfilled that requirement.
And how long has you been working for your own land surveying firm?
1980.
If I may approach the witness. Mr. Diorio, I'm going to show you a document pre-marked as Proponents Exhibit 18.
Okay.
You identify that document for me?
This is my resume from 2023.
And is that a true and accurate copy of your resume?
Yes,
From that
it is.
time? Mr. Hartman, the Attorney General would ask the Proponents Exhibit 18 to be admitted in full.
Mr. Farside?
No objection.
No objection. Admitted in full.
Mr. Diorio, could you please describe the services that your company provides?
We focus on survey work, so that's boundary work, topographic work. We're engaged with global positioning systems or GPS. We do high definition laser scanning. We do drone photography. I'm a licensed pilot, drone pilot. We do project planning, design, and supervision. We do layout, land use presentations. We do on-site sewage treatment design, soil evaluations, freshwater and coastal permitting, and floodplain management.
And in what parts of the state of Rhode Island do you practice?
I cover most of the state of Rhode Island. I focus on Washington County.
And are you familiar with the Weekapaug area?
Yes, I am.
And how are you familiar with it?
I've done numerous surveys in the Weekapaug area. I served here as a young man and I fished there routinely.
And have you served as an expert in a legal case before?
Yes, I have.
How many times have you done so?
I would say somewhere between 6 and 12.
And in what kinds of legal matters, have you served as an expert?
Typically boundary disputes.
And what was your role in those boundary disputes?
An expert for one side or the other.
Mr. Diorio, is it common that land surveyors need to interpret plats or maps?
Yes, it is.
And why do surveyors need to interpret plats or maps?
Maps, sometimes in conjunction with deeds, help surveyors develop a sense of how to reconstruct the parcel boundaries and engage in a faithful reproduction of those boundaries, known as following in the footsteps in the profession.
What do you mean by that, by following in the footsteps?
Well, typically there's an original surveyor. You folks have been looking at plats this evening, so there was an original surveyor to that plat. If a surveyor was to reconstruct any of the boundaries of that plat, they would be referring to this instrument to assist them in doing that.
And how many maps have you personally reviewed and interpreted in your career?
I'm sure we're somewhere in the thousands.
So going back to what you said before, what steps would a surveyor take to follow in the footsteps of the original scrivener as you described it?
Sure. Well, usually there's an analysis of the instruments. Typically on the record, they would be plats, they would be deeds, they might be other instruments or evidence. And in developing or analyzing that data, that often assists in the faithful reconstruction that I alluded to.
And in this matter, Mr. Diorio, you were only asked to evaluate maps, is that correct?
That is correct.
And so in evaluating a map alone, like those that we've been discussing in this matter, what are the elements that you would look to interpret what that map is saying?
Well, there are various elements on the map. Perhaps I can refer to this one. There's line work on the map that is going to help us reconstruct boundaries, road networks, etc. There's often physical evidence indicated on maps, so these would be survey monuments, drill holes, iron pipes, etc., that would allow us to aid us in that reconstruction. There are dimensions on the plat. These would be distances, sometimes directions.
Would the writings on the map also give assistance?
Well, the writings, I'm referring to the dimensions, the angular information. There's notations on the plan that might be helpful.
You mentioned line work. Do surveyors use line work or other markings in the same way?
Not necessarily. The construction of maps is both part science and both art. So different surveyors might use line work differently on their respective plans. For example, I might use a continuous line type. A continuous line type is something like this. I'm pointing to the plat that shows a straight line, not dashed or dotted, but continuous. To portray a certain element, another surveyor might choose a different line type to represent that very same thing.
Would it be fair to say, though, that a certain line type might be used consistently within a given map?
Yes, I would agree with that.
You talked a little bit about details that surveyors look to in interpreting maps. What determines how much detail a surveyor might use while drawing a map?
Well, that might be a function of the client's dictates. So, of course, the surveyor is typically contracted by a client, so there's an objective for making the map. So whatever the client's needs or requirements might be would largely drive the content of a map, but today they're guided also by a set of standards. So when surveyors construct maps, they have to construct them in accordance with guidelines.
So am I correct then that, especially when looking at historical maps, there may be particular reasons why surveyors might not include every detail when rendering a particular area?
Yes, I would agree with
Mr. Diorio, turning to the subject of this case, you reviewed a series of maps depicting the area that we have been referring to as the Spring Avenue extension. Is that correct?
that. That is correct.
What did you review, just generally?
I was provided a series of maps. My goal, my dictate was analyze the line work on those plats to ascertain whether the area in question was part of a road network.
And Mr. Diorio, without sharing any final conclusions, did you reach an opinion as to whether that strip of land that we've been referring to as Spring Avenue Extension is part of the road network in the Weequahic area?
Yes, I did.
All right, Mr. Diorio, I'm going to show you an exhibit now that is marked Joint Exhibit E. And members of the subcommittee, this is one of the exhibits that was previously provided, but if anyone needs a copy, I'm happy to share one. Mr. Diorio, do you recognize this exhibit?
Yes, I do.
What is it?
This is a map of building sites at Weequahic Point in Westerly, Rhode Island, dated 1886.
Are there any other details identifying the map that you can see?
There are a number of lots. There's a road network. There's a Quannacontag Pond. There's Atlantic Ocean.
And have you seen this map before? Or yes, have you seen this map before?
Yes, I have.
And in what capacity have you seen this map?
This was a map provided to me by the Attorney General's office as part of my review for my.
Joint Exhibit E has been previously submitted and stipulated to by the parties, and we would move to enter it in full.
Has this already been entered in full?
Yes. It's a joint
exhibit. Okay. Regardless, it's entered in full.
Mr. Diorio, you have to your right, to our left, a large-scale version of the exhibit. Can you confirm that this is the same map as the one marked Joint Exhibit E that you have in your hand?
Yes, it is.
And do you agree that this Joint Exhibit E is the same map that you refer to as Map A in your expert report?
I don't have my report, but I'll take it.
Mr. Diorio, what does this map show at a high level?
So once again, this is a map of building sites, shows a series of lots, shows a road network, Quannacontag Pond to the north, the Atlantic Ocean to the south.
Do you know what the purpose of this map was?
I will surmise that it is a map of proposed building sites.
Are you able to tell us whether this map was recorded by the town of Westerly?
Yes, I can.
And what date was it recorded, if you can tell?
May I?
Of course.
That would be recorded on March 31st, 1915.
Thank you. And do you see on this map the area of dispute in this matter? And can you point it out for me?
Yes, I do. And it's right in this area right here. I'm referring to an area on the map between lots 17 and 18 on the plat.
Mr. Diorio, I'm now going to show you an exhibit that is pre-marked Proponents Exhibit 19. Mr. DiOrio, do you agree that this is a close-up of the area that you just indicated to on the larger joint exhibit E?
Yes, I do.
The Attorney General would move for proponent's exhibit 19, to be admitted in full.
With the stipulation that it's a portion of the larger joint exhibit E, that's fine with the district.
Admitted in full.
Mr. DiOrio, can you please describe what is shown in this close-up image?
So this is a blow up of the portion of the plat that we started with. I'm pointing to, once again, the area between lots 17 and 18 on the plat. Same area right here.
Is there any other information that you can tell from the map as it's presented to you?
It is a strip of property. It's 50 feet wide. It is bounded on the west by lot 17 and on the east by lot 18. Northerly by Niagara Avenue, southerly by Sosa Avenue.
How do you know that it's 50 feet wide?
Well, because right here, there's the number 50 with a foot mark after it. And you'll note that to the east and west, there are leaders and arrowheads, really indicating that that is a dimension.
Mr. DiOrio, for the uninitiated, what is a leader?
I'm sorry, the leader is, so a leader is part of a dimension line. So the leader is the short segment that is right next to the arrowhead. It's somewhat obscured in this particular version, but if you drill down on this, you'll notice that there's a small leg extending beyond the arrowhead that's called a leader.
So these markings then are different from a boundary? Is that correct?
I'm sorry, the question was?
I'm sorry, I'll repeat. So these markings are different from a boundary, is that correct?
Well, a boundary represented on this close-up would be something like this line type. This is a dimensional. Those are two different things.
And so how does this area that we've been referring to as the Spring Avenue extension compared to the surrounding lots that are depicted on this map?
So the line work of the strip that you're discussing is not a closed figure. And by that, I mean, if you take a look at the abutting lot to the east, number 18, you'll see that it's an enclosed figure, polygon, an enclosed polygon, indicating a lot. The roadway, the piece of roadway that we're talking about, you'll notice is not a closed polygon, suggesting that it's part of a larger network. Additionally, the lot, I'm referring to 18 on the plat as an example, has a lot number, has a lot area, has dimensions associated with it, where those things do not appear on the strip of property that we're discussing. There is, although not evident on the blow up, more evident on the larger scale, there's a building line. I'm just selecting the line work that is between lot 6 and 17 on the plat. I'm pretty sure that's identified as a building line in other areas of the plat. You'll notice that that line work is not evident on the piece of the strip of property that we're discussing.
Thank you. And how does this area that we're referring to as Spring Avenue extension compare to the other roadways depicted on the map?
Oh, well, very similar. You'll notice that this is all open, so no closed polygons on the road, the piece of road network that we're looking at. You'll also see the similar 50-foot dimension appearing to the north. That is that's opposite and east of lot 57, appearing at the northerly portion of the upper portion of this plat. You'll also see that same dimension. Well, to pick this one right here, 50-foot dimension on Sosa Avenue. Similar, if not identical, to the 50-foot dimension on the strip of property that we're discussing.
And so from reviewing this map, what is your professional conclusion about the area that we've been referring to as the Spring Avenue extension?
I believe that the intention of the Scrivener here, just based on line work, is that this strip of property that we've been discussing is a piece of the road network that abuts Ninigret Avenue to the north and Sosa Avenue to the.
And so going back for a moment to Joint Exhibit E, the larger map, is there anything on this map that would indicate that this portion of the roadway is private?
You're referring to this portion of the roadway that is the strip of property between lot 17 and 18?
Yes, which is the area that we've been referring to here as Spring Avenue Extension.
Yes, the answer is no.
And are there other roads on this map that are marked as private?
Yes, there are.
Mr. Diorio, I'm now going to show you an exhibit that is marked as Joint Exhibit F, and I'm just going to take a moment to put that up on the document. Mr. Diorio, do you recognize this exhibit?
Yes, I do.
What is it?
This is a map of property belonging to John A. Taylor, situated at Leechport Point, Westerly, Rhode Island.
And have you seen this map before?
Yes, I have.
And in what capacity have you seen this map?
This map was provided to me by the Attorney General's office as part of my review for my report.
Mr. Hartman, this exhibit was stipulated by the board, and we would admit to have it entered in full.
Entered in full.
And Mr. Diorio, you'll see that there's a large scale version of this exhibit to your right, to our left. Can you confirm that this is the same map that is marked Joint Exhibit F, which you have just reviewed?
Yes.
I would like to, and do you agree that this Joint Exhibit F is the same map that you refer to as Map B on page 3 of your expert report?
I don't have my report with me, but I'll take your word.
Just to clarify a moment for the record, Mr. Diorio, do you recall that this map is the map that is found at Plat Book 3, page 18?
Yes.
And so just to confirm for the record that this map here is one that you identify as Plat Book 3, page 18.
Yes.
Mr. Diorio, what does this map show?
It shows a series of lots located to the southwest or lower left of the plan. A series of lots in road networks, Quantico Pond, although identified as a pond to the north, and the Atlantic Ocean to the south.
And as with the last map, do you see here the area that is in dispute in this matter? And can you point to it for me?
Yes, I do. It is this area right here. I'm referring to the strip of property between lots 17 and 18.
And that's, again, the area that we've been referring to as Spring Avenue Extension. Is that correct?
That is correct.
Mr. Diorio, I'm going to show you now an exhibit that is pre-marked Proponents Exhibit 20. Mr. Diorio, do you agree that this image that I've just handed to you is a close-up of the portion of Joint Exhibit F to which you just indicated?
Yes,
Mr. Herman, the Attorney General would move for the exhibit pre-marked as Exhibit 20 to be entered in full, with the stipulation that it is a portion of the length of Joint Exhibit F.
Final with the district.
Admitted in full.
Can you please describe what this close-up image shows, Mr. Diorio?
so the close-up is, again, showing a portion of the larger plat. It's, delineates a series of lots. Integrate Avenue to the north, Sosa Avenue and a rocky beach to the south. In the area in question, again, a strip of property between lots 17, 18 and the plat.
Compared to the surrounding lots, how does this strip of land compare?
So there are some similarities that we've touched upon previously. The strip of property is an open area, that is, it's not a closed polygon, indicating that it is a portion of the road network. Ninigret Avenue to the north, Sosa Avenue to the south. The adjacent properties, just to use them as an example, 17 and 18, you'll see that those are closed polygons. Other lots on the plat, although not 17 and 18 specifically, have dimensions, lot numbers. There are no areas on this particular version of the mapping. And I don't believe there's a building setback on this particular.
You mentioned dimensions in lot numbers. Just to clarify, are you saying that those appear on the lots but not on Spring Avenue Extension?
They appear on the lots. I'm going to choose lot 16 as an example, has a frontage of 82 feet and a depth of 187 and change. Those are the dimensions of that lot, at least the northerly and easterly property lines. But you see that there are no dimensions on the area in question.
And how does this strip of land, Spring Avenue Extension, compare to other roadways on the map?
Very similar in that they are open, not closed polygons. On this particular version, there are no dimensions, but just visually, you can see that they're approximately the same.
And so from reviewing this map, what is your professional conclusion about this area that we've referred to as Spring Avenue Extension?
I believe that this strip of property bounded westerly by 17 and easterly by 18 on the plat is a connection of the road network bounded northerly by Ninigret Avenue, southerly by Sosa Avenue.
And so going back just a moment to Joint Exhibit F, is there anything on this map that would indicate that this portion of roadway that you have been speaking to is identified as private?
No.
Thank you. I just wanted to take the temperature. I know that it's just after 9 o'clock, so I'm happy to pause or continue testimony at the committee's preference.
How much more do you think you have?
A bit more. I'd probably say half an hour or so.
All right, we can pause now if that works for everyone. Because I don't want to rush you and then stop you if questions develop as you're questioning him. So we can continue it at our next hearing. All right.
Thank you.
You're welcome. And with that, we will adjourn.
Yeah,
No,
Chair.
yes, Director Willis.
So I just want to reiterate that we have a meeting set up next month in April. However, we are working to set up additional meetings and we might be meeting before the meeting that's already scheduled in April. So I just want to give everybody a heads up that, again, I'm trying to schedule more meetings. We might have one scheduled before the April meeting.
Possibly earlier too.
And that's right. The chair had asked that we start the meetings earlier on 5 o'clock, if that's acceptable to everybody.
Yes.
And maybe go till 8, maybe go till 9. Again, trying to make sure we get everybody's testimony in a timely fashion. We'll be in touch.
Thank you.
All right. Thank you, everyone. Be safe.
Thank you.
That's my decision.